What's up, everybody? So we're continuing to go back and have a look at what was being printed in the press at the time of Steven Avery and Brendan Dassey's arrest and what was being printed at the time of their trial. So before we jump into today's clippings, I want to go back and have a look at one I talked about the other day. There's one specific sentence in one of them that really made me think about something else. And I will put it up on the screen here for you. Now it states, now this is from Jerome Fox, one of the judges. He said he reviewed the video, audio, and transcripts of Brendan Dassey's statements, which he sealed to prevent publicity that could taint a jury pool. So they were worried about information getting out that could taint a jury pool. And this is from May 13th, 2006. They're worried about information getting out that could taint a jury pool from May 2006. But yet, the interviews and press conference Ken Kratz gave on March 1st and March 2nd, 2006, a couple of months before this article came out, those press conferences were okay. Ken Kratz going out there stating everything that happened in the case, everything they believed happened in the case, giving every single gory detail that he believed happened in the case, was not going to taint a jury pool, was not going to get publicized. Everyone in the area wasn't going to hear this and then make up their mind. Ken Kratz knew exactly what he was doing, but yet this judge sealed stuff to prevent a jury pool from being tainted, but yet Ken Kratz was allowed to go out there and say whatever he wanted, because for some reason, him doing that wasn't going to taint a jury pool. Absolutely ridiculous. All right, now this next article is from May 24th, 2006, and it is from the Janesville Gazette. It states, State District Court rejects Steven Avery's attempt to appeal. A state court has refused to immediately accept an appeal of a ruling that denied Steven Avery another preliminary hearing into the murder and mutilation case against him. The Second District Court of Appeals on Tuesday denied petition from Avery to make up the matter right now, which would have stopped all further court proceedings. Manitowoc County Judge Patrick Willis rejected last month Avery's request for a second preliminary hearing, ruling the new charges that included rape, kidnapping were closely related in time and place to the evidence presented at Steven Avery's first preliminary hearing. A deputy clerk for the Court of Appeals said Wednesday the rejection of Avery's petition means the criminal case can proceed in circuit court. A formal appeal of the second preliminary hearing decision could be made after the case is resolved in the lower court. This next one is from June 17th, 2006, and it is from the Madison, Wisconsin State Journal. Dismissal of Avery case asked. Lawyer says publicity has damaged his right to a fair trial. Here we go. This is exactly what I was talking about. A whirlwind of publicity over murder and kidnapping charges against Steven Avery has damaged his right to a fair trial so much that the counts should be dismissed, according to his attorneys. Dean Strang filed a batch of pretrial motions Friday, the last day to submit them before the Manitowoc County Circuit Court Judge Patrick Willis considers them at a July 5th hearing. Strang keyed heavily on publicity throughout the motions, contending authorities' comments during multiple news conferences turned potential jurors against his client, forcing the judge to either dismiss all but one of the charges, delay his trial, or move the proceedings out of Manitowoc County. He also argued statements Avery made to reporters who interviewed him face-to-face in jail should be barred from evidence. So, Steven Avery's lawyers realized right away that what the judge ruled in Brendan Dassey's situation, where they were sealed to stop a tainted jury pool, but yet the same thing was done in Steven Avery's case, and it was allowed, and nothing happened. Ken Kratz was allowed to give interviews and press conferences talking about everything, but for some reason in their heads that wasn't going to taint a jury pool. Just insanity, pure insanity. This next one is from the Janesville Gazette from June 22nd, 2006. Teen's attorney wants to dispute confession. The attorney for a teen accused of raping and killing a woman with his uncle wants a chance to tell a jury the teen's confession to police was unreliable, according to court records filed on Wednesday. Brendan Dassey gave a 3-hour videotaped confession on March 1st to investigators. The prosecutor and defense attorney say a judge previously ruled the prosecution can use the statement to police as evidence. The motion filed Wednesday by attorney Len Kaczynski says he asks that he be allowed to present evidence to a jury during Dassey's trial on the credibility of the teen's confession to police. This next one is from June 25th, 2006, and it's from the Madison, Wisconsin State Journal. Avery fund shift to lawyer ruled okay. Stephen Avery did nothing wrong when he transferred money he received from a lawsuit settlement to his attorney, a judge has decided. Avery won $400,000 in a wrongful conviction civil suit against Manitowoc County. Now remember, that was supposed to be $36 million, but he had to settle so he could get money to pay his attorneys. Avery won $400,000 in a wrongful conviction civil suit against Manitowoc County and was deemed ineligible for public defense and hired attorneys Dean Strang of Madison and Jerome Buting of Brookfield. Halbach's family filed a wrongful death suit against Avery and later Dassey. The family also filed a motion to have a third party control Stephen Avery's assets. Patrick Coffey of Appleton, representing the Halbach family, contended Avery illegally transferred all of his assets to Strang. Coffey asked the judge to place Stephen Avery's assets in a receivership and require Strang to request the money as needed. The timing is suspicious. Manitowoc County Circuit Judge Daryl Dietz said in his ruling, but it is equally plausible it was based on Avery's receipt of his settlement, his immediate loss of public defender services, and his negotiation to obtain competent, suitable counsel just before the Halbach suit was filed. Avery became insolvent or broke after the transfer of funds to Strang, which is in violation of state law, Coffey said in a motion at a hearing in May. Coffey also said Avery illegally transferred the funds because the transfer occurred 3 days after Avery was sued in civil court. State law prohibits the transfer of funds after being named as a defendant in a civil complaint, according to court records. As of May 23rd, Strang said he already has earned nearly 60% of the funds, and Dietz says in his ruling that due to the cost of an adequate defense team, Strang and Buting likely will not receive anything close to their hourly rate by the time the case is concluded at the trial level. Stephen Avery and Dassey face life in prison if convicted of the homicide charges. All right, those are the ones we are going to go over today. But the big thing for me, like I talked about earlier, is that the fact that Stephen Avery is the fact that they sealed information in Brendan Dassey's case so that it wouldn't taint a jury pool, but yet Ken Kratz was allowed to go say whatever he wanted because in their mind that wasn't going to taint a jury pool. That is literally the exact same thing. Why was one sealed and the other wasn't? Why was one attempted to seal and the other one said it's just okay? Ken Kratz can go out and say whatever he wants, do whatever he wants. It's fine. It's not going to taint the jury pool because it's not being broadcast everywhere locally all over the country. It's just absolutely ridiculous that Ken Kratz was able to do that and nothing was done about it. Let me know what you think. Leave some comments below. I hope you're having a good day, and I will see you again soon.